Hi, everyone. Welcome to our Facebook Live broadcast. I'm Steve Altition, Director of Client Partnerships here at Pacific Cascade Legal. And today we have attorney Darin Wisehart to talk with us about how to prepare for a Chapter 7 bankruptcy meeting of creditors. Hey, Darin, how are you doing today?
I'm great. I'm great. Thanks for having me today.
Well, thanks for joining. And let's start with just the basics of the basic question. What is a meeting of creditors?
The meeting of the creditors in a Chapter 7 is the opportunity for trustee and creditors to ask questions dealing with your filing. Anything you filed with the court, they get to review them, and then they get to ask questions, just what they feel like, they want to know and follow-up information. Trustee will usually ask more questions. The creditors typically only have a few, but you want to be prepared for both of them to show up if they choose to.
So why is there a meeting of creditors? What's the purpose of it?
So the meeting of the creditors ensures that your documents are filled out correctly, that everything is where it needs to be in order to allow the case to move forward, but also allow the judge to review the case at the end and say that everything was fulfilled as far as the statutes, because the statutes are those laws that govern bankruptcy, and you've got to meet all of those. You got to meet all those requirements in order to get through the process. And the meeting of the creditors, what's called a 341A, is really just it's just the opportunity for everyone to double check the documents, make sure everything's accurate, and then maybe ask you some follow-up questions on some of the materials that they find.
And they call it meeting of creditors, but doesn't the trustee run the thing?
Yes, absolutely. So the trustee will be the conductor. The trustee will start, they'll call the case, they'll put everything on the record. Their job is to administer the hearing in a very professional, a very polite way. They don't rip into you or any of that kind of stuff. They look over the documents. They'll ask you or your attorney multiple questions. And a lot of the questions will come out as far as just basic stuff that you've been answering throughout the course of the process. So if you filled out your initial schedules correctly, most of those questions the trustee asks you will be in those documents as well. So you're ready for the hearing. You just don't know it most of the time when you prepare for it.
So do the creditors generally ask questions? Do they have to ask questions? Do they generally not ask questions? How do they sort of fit into that?
In a Chapter 7, I always knock on wood because you don't want them to show up. You don't want them asking questions. For the most part, you prefer that they don't. And a lot of times they don't show up. If they don't have anything to ask, there's not really a lot of materials to review. There's not a lot of questions that they can throw at you. It's not like a TV session where you feel like you're going to be on the stand and you're going to get grilled by somebody. Even if a creditor shows up, usually their questions are pretty outlined to one thing or two things. And usually your attorney can have you ready for them. But the creditors don't often show up. The trustee's always there. They're required. But the creditors, if they don't have anything to say, if they're just a general unsecured creditor, most of the time they will not show up.
Got it. Just kind of a quick question I just thought of. They don't send their attorneys, do they? Or do they?
Hit or miss. It depends on how serious they are, right? And a lot of times, if you work through the documents with your attorney, you'll see the questions that they're asking, and you'll be able to outline maybe some of those problem points that a creditor might show up for. And they, periodically they'll bring out the heavy guns for certain cases, but very, very rarely does that happen. And it's not something I tell my clients to worry about at all, because you're not going to prepare any more or any differently for them as you would just for the trustee.
Got it. So what kind of advice can you give to the debtor in terms of just preparing for the meeting of creditors?
There's a lot of things that I usually will say. Okay, so typically the first thing I start with is don't stress about the hearing. And we are all human, so we all are subject to our own human brains, right? And that sometimes when we don't know what to expect, we fill in the blanks with things that will not happen.
Yeah.
Okay, so we don't want to stress about it, because a lot of times you're prepared for it, you just don't know. And in my office, we ask these questions 3 or 4 times over the course of the process, So once we get to the hearing, the client already knows exactly what's going to get asked. They know what's coming. So no stress. In the actual hearing, the couple of things that I counsel everyone to do first is tell the truth. You're under oath. So you want to make sure that you're telling the truth. And 99 times out of 100, the only way a Chapter 7 case goes sideways is if somebody doesn't tell the truth. And that doesn't mean you have to tell down to the penny. No trustees care if you give a bank account that's $270 rather than $271. You want to tell the truth, obviously, but if you miss $1 here and there, it's not the end of the world. We can always tell, the trustee afterwards, but you want to tell the truth and remember that you're under oath, but you also want to be short and sweet with what you're doing. So if you're answering questions, you don't want to give them a long-winded answer. Most trustees don't care why you got there. They're not there to evaluate your history or how you got to the situation. And creditors usually don't care about that either. So it's important to answer questions just exactly what was asked, be polite, and then at the end of the hearing you can kind of look and say, well, how did it go? And that's what you will do with your attorney. Another thing, a very important thing you can do is read your materials that are sent to you by the court and the attorney. Those are always important, and some people don't. They choose not to read them. We know we're all human, but you want to make sure you read those because they have a lot of important information. And one of the first questions the trustee in the Oregon district asks is, did you read the trustee information sheet? And of course, that answer needs to be yes. If it's not, then the trustee will pause and give you 5 to 10 minutes of very, very awkward silence to read this document. And you want to make sure you're ready with that kind of stuff before you go in. You'll also discuss the hearing with your attorney. That's something that you'll do. And a lot of times you'll have documents that need to be sent over to the trustee. So you'll run through those. Those change with each district. So you want to make sure, and it doesn't change too much because it's still required of the U.S. Trustee's Office, but you'll see some variance here and there. But the primary is just don't stress. Try to prepare as best you can with your attorney and make sure that you're reading the stuff that comes through.
Yeah. And it's interesting because all of the stuff you said really feeds into telling the truth. What I see a lot of times when people get a little sideways with that is when they're trying to read the mind of the person asking them the question. What do they want to hear? And it can go sideways real fast at that point.
Yeah, and I can tell you, just if a client were to say that, I'm trying to address what they want to hear. My first statement is, well, what's the truth? What's the truth? That's the easy one. And then, of course, I can tell you most trustees, they want you to be short and sweet with your answer. If they ask a yes or no question, they just want yes or no. They don't want you to go, yes, well, let me tell you about the time in 1992 where they don't want any of that. They want, let's get this hearing done. Let me get my questions. And sometimes every once in a while, somebody gives more information in those questions, and you just want to make sure you're keeping it short and sweet.
Yeah. So any advice on what the debtor should do on the day of the meeting? You got them prepared. Mm-hmm. They're think they're ready to go. They're ready to go. But a lot of times the day of the meeting, the stress levels, the rush, things happen. So what do you tell your clients, about, okay, day of the meeting, make sure of this.
Make sure you're showing up 15 to 20 minutes early. And if you're the type of person that is habitually late, make it 30 to 40 minutes early, because you'd rather sit there and be ready when the trustee is ready rather than have it go over and then you end up having to either postpone, maybe set it to another date. Those are things that you don't want to have to do. You want to get this thing done with, right? And this is usually a normal chapter 7 341A hearing, the trustee hearing, meeting of the creditors. All of those are terms that you'll hear when you use this. They're used interchangeably in bankruptcy world. They'll typically only go 10 minutes. So all of the thought process, all of the sleep that somebody might miss is for 10 minutes. And it's 10 minutes of a conversation with your neighbor that you really don't have to worry about. It's pretty polite. We have excellent trustees in Oregon. They do a very good job keeping it professional and asking the questions that need to be asked. So you don't have anything to worry about. Be in there a little early. And then make sure you have enough time to talk with your attorney prior to the hearing. I like to talk to people about 15 minutes before, and then I'd like everybody to just get settled in. And typically I'll bring people to my office because it's currently on a Zoom call, and that was just updated a few months ago. So they're doing the Zoom calls now rather than just the phone. And that'll change a little with the district too, but I think a lot of them are doing the Zoom calls. And I like to set up and just make sure everything is ready to go. When you come in, no need to bring anything. If you've sent your materials to your attorney, you don't have to bring stuff, but it's a good idea to bring your social security card and your driver's license. Those are always good backdrops to have. When you come in, wearing professional clothing is not necessarily needed. Obviously, your attorney will have that because that's their normal costume. But when you come in, anything that's just normal clothes, a t-shirt is fine, whatever's comfortable. Don't wear a suit or a tuxedo or any of this kind of stuff. Just wear what's comfortable, but make sure you have sleeves and things. Don't be ready for the beach. We'll say that.
Yeah. It reminds me a little bit. We've done a couple of Facebook Lives on how to act in front of a judge, what to wear in front of the judge, what not to do in front of the judge. And it's pretty similar. And one of the questions that gets asked or happens without being asked is bringing their kids to court. Now, in this particular case, is that a good idea or not?
The kids could be there. Okay, so we always start with what is possible if you have no other choice. But here's the beauty of the hearing. The hearing, we want to be done. We want to get it done in the 10 minutes. And usually if you're distracted, which when kids are around, I have a child as well, and you can chase them around for a while. You want to make sure that your focus is on what you're trying to accomplish. And that is get this hearing done with. Because once this hearing is done, for most Chapter 7 clients, you're pretty much done with the case. And so you want to get this thing done. If you bring your children in, you're going to have another distraction, something else that happens. Maybe they have sound onto the device, or they're running around or doing something. Try to get them taken care of and squared away with a babysitter or somebody, maybe a grandparent, come in and watch. That way you can come into the hearing and just focus on the hearing. And it also helps to just calm the situation down, to just make sure that we take away all the extras and just focus on what the hearing is about today.
Yeah. Yep. You had said earlier and emphasized it, be early. Is there a consequence if you're not? If you show up 15 minutes late, I mean, can't you just sort of make that no big deal?
It will be a big deal, but it might not always be said. And here's the thing: trustees are people, and they have schedules and they have things to do as well. So when your hearing is scheduled for 11 o'clock and you saunter in at 11:20, then the trustee may or may not be happy about that, and they may have already reset it for 2 weeks later. And every once in a while, they can push to dismiss your case because you didn't do what you were supposed to do, which is be present for that hearing. Especially if creditors show up, then the creditors are there, everybody's there, you're not there. And the trustee can push to say, hey, you had notice about the hearing, you knew it was there, you decided not to be there, and we're gonna move to dismiss your case. And they can do that. Typically they don't if it's the first offense, but I always tell people, this is your opportunity to really get everybody in your corner. And the trustee is much more likely to be in your corner if you show up on time, you sent the documents you needed to, and you're ready to go. And if you don't do those things, then you risk the unknowns of, we don't know what's going to happen with all the different aspects. It'll probably be all right. You're a good attorney will be able to work through it, but you just don't want to deal with those things if you can help it.
Yeah. I mean, things can happen, but I imagine you would appreciate a phone call if they are going to be late.
Yeah. And an attorney can always, if this has happened a few times in my career, I always tell people, try not to do that. Try to make it a priority to be there because we want to get it done. But if you have something really that did come up and you just cannot help it, then trustees are very friendly about that. They're okay. They realize real life happens. And, if there's a valid reason, the trustees will almost always set it over a week or two so that you can be there.
So What happens after the meeting? Is that the end of it, or what goes on?
So after the meeting is finished, then of course you want to talk with your attorney. You want to discuss how it went, what the cues were, and what follow-up might need to be happening. Once that's done, though, the case goes relatively quiet in Chapter 7. There's a couple of things that may come up. So, of course, there's an objection period of time so that the creditors can come in and say what they want to say if they have problems with what's going on. Your attorney will keep an eye on that, or if you're representing yourself, you'll keep an eye on things that come in the mail. But it goes relatively quiet. A typical case, Chapter 7, it goes quiet after that. There's reaffirmation agreements that you have to do. We can talk more about those, but those are basically the idea of re-upping a car loan so that you can continue paying on it and keep the car. And that's something that you can work on after the hearing. Sometimes you have other things that you need to work on in a case, but most cases will just go quiet. You're waiting your 2.5 months until the judge can review the case and then an order of discharge if everything goes well. We always knock on wood. But if everything goes well, then the judge will review and sign the order of discharge at the end of the case, and then you're out of the case and done.
Yeah, I love it. Well, that was incredibly informative, and I'm sure that just hearing that can make people feel, okay, I think I can do this. So thanks for being here today to talk about, really just what goes on in those meeting of creditors.
Yeah, no problem. No problem at all.
All right. And thank you everyone for joining us again today. If anyone has any further questions on today's topic, you can post it here and we can get you connected with Darin. Until next